Okay, so good afternoon and welcome to today's Learn and Share conference call. I'm Russ Derry, the Director of Education for Epilepsy Foundation of Michigan, and I'll be moderating this discussion. The topic today is disability laws, your rights in education, employment, and beyond. And we're pleased to have as our speaker Mark McWilliams, who is an attorney and the Director of Public Policy and Media Relations for Michigan Protection and Advocacy Service. So Mark, could you briefly introduce yourself and talk a little bit about your background and describe your experience with this topic?
Sure. Thanks, Russ, and thanks for inviting me. I'm an attorney with Michigan Protection and Advocacy Service. That is the federally designated protection and advocacy agency that serves people with disabilities in Michigan. We're set up as a private nonprofit organization, so although we're federally funded, we aren't connected with state government or the federal government. We are independent. I've been an attorney with the protection and advocacy system in 3 states since 1990, and came to Michigan in 1997. Came here for the weather, I served first as our information and referral director, then as our director of education advocacy, then both for a while, and then now for the past 4 years I've worked as the director of public policy and media relations.
Okay. So, several federal and state laws exist to protect the rights of people with disabilities, including epilepsy. This includes laws like the Americans with Disabilities Act, the Individuals with Disabilities Education Act, and many more. Can you talk about the basic principles on which disability laws are based and give a few examples of how they provide people with disabilities access to school, work, home, and the community?
Sure. Most of the laws are premised on the principle that disability is a natural part of the life experience, that it's a trait that many of us are going to have at various parts in our lives, and that the issue is how do people with disabilities get access to the community? How do they get the supports necessary to fully participate in all aspects of life, including school, employment, where you live, what kinds of things you get to do in your free time, who you associate with, and how you live your life. So most laws are designed to, 1, protect against non-discrimination on the basis of disability, and 2, provide access to people to all aspects of community life, starting at birth, really, with special education early on, and going through life with the Americans with Disabilities Act, the Fair Housing Act, and also a lot of state laws.
Okay, great. So let's talk about the 2 major laws that relate to education, the Individuals with Disabilities Education Act, or IDEA, and Section 504 of the Rehabilitation Act of 1973, also just known as Section 504. So can you start by describing the basic intent and scope of each law and some of the key differences between them as they relate to education?
Sure. And let me start by saying that there is a 3rd law in Michigan. That is the Michigan Mandatory Special Education Act, which predates all of those things, and has some important differences in how it treats students with disabilities. The Individuals with Disabilities Education Act was passed in 1975, signed by President Ford. It applies to education for mostly K through 12 education. In Michigan, it extends from birth to age 26. Most states, it extends from ages 3 to 21. It's designed to provide access to education, to public school, and to make sure that students with disabilities have supports necessary so that they can participate in school, so that they can advance in learning the general curriculum, have an opportunity to pursue graduation with their peers, and to be part of the public school system just like everybody else. Section 504 actually applies to all federally funded programs, but it has a particular application to education. it says that in all federally funded programs, you cannot discriminate on the basis of disability. It's the basis for the Americans with Disabilities Act as well. And since most public schools receive some federal money, nearly all public schools will be subject to Section 504. So that means that they have to provide equal access to educational programs, including both education and extracurricular activities for students with disabilities. They differ in that Section 504 defines disability a little bit differently. It defines it in a functional way. It doesn't have a list of conditions that would qualify you as having a disability for protection under the law. Instead, it looks at whether you have any disability that limits your ability to function in one or more major life activities. IDEA has categories of disability. There are 13 of them, and they're defined in the statute and the regulations.
Okay, and then in terms of funding, what's the difference in terms of funding for accommodations and services between 504 and IDEA? So IDEA has a separate source of federal funding. The original intent of IDEA was to fund 40% of the cost of special education services. In reality, it's more like about 10 to 13%. And then the states and local districts kick in the rest. You may have seen in the budget proposal that the governor put out yesterday, there's an increase in the percentage of money that the state would pay towards special education, increasing it from about 28% to about 32%. Locals then make up the rest of that. Section 504 doesn't have a separate funding source, but again, remember that it's based on whether or not a school district receives federal funds of any kind. So there isn't separate funding for Section 504 supports, but it is based on receiving federal money. Okay. And can you talk just a little bit about kind of the different circumstances under which someone might apply for assistance or services or accommodations through 504 versus IDEA? Are there
Sure.
any general guidelines, or is it pretty much all on an individual basis, whether you do one or the other?
Well, think of some of the language in Section 504 is the same as under IDEA, but think of Section 504 as sort of a fuzzier, blurrier version of IDEA. The requirements are much more general and to some extent left to the discretion of school districts. For example, there isn't a requirement that you have an individualized education program under Section 504, but you have to have a plan that is put together by a group of knowledgeable people to provide accommodations or supports. Typically, I mean, an example of where you might request a Section 504 accommodation is if, say you're a student who has a mobility-related disability and you have trouble getting from one class to another. You may not need any specialized support to take advantage of education, the education services in the school, but you may need some accommodations so you can get around from room to room, so you can actually get into classrooms, use the bathrooms, take part in extracurricular activities. Those might be circumstances where you would look at a Section 504 accommodation as opposed to an IDEA accommodation, where you may not need the kind of specialized support or additional services that are necessary to give you access to education. The other example would be a situation where, say, a person didn't fit into one of the categories of eligibility under IDEA. Let's say that you had a mental illness, and mental illness is actually not one of the 13 categories under IDEA. There is a category called emotional impairment, but it's different. So it's possible that if you're struggling in school because of a disability that may not be listed, or let's say you had a learning disability that didn't put you so far behind the rest of your classmates that you might not qualify as having a specific learning disability under IDEA. The Section 504 definition is broader, and so you might be able to qualify under Section 504, and when you wouldn't qualify under IDEA.
Okay, right. Is ADHD a good example of a condition where 504 might tend to be more appropriate than an IEP? I guess it depends on the severity of it, but
ADHD is a tricky one because it's not listed as one of the 13 categories of eligibility under IDEA, but there are a number of ways that it might fit one of the categories. It might be considered an other health impairment, which is a category. If it fits the criteria for learning disability, it might be there. It might fit the category of emotional impairment, but it also can be a disability under Section 504.
Right. Okay. So what are the primary means by which parents can facilitate the development and implementation of an effective 504 plan, and how are disputes resolved when they occur?
Well, that's going to differ from district to district. As I mentioned, 504 is kind of a blurrier version of IDEA, and districts have some discretion in how they set up their process. So for every district has to have a Section 504 coordinator, and they have to have a plan for how they're going to provide services and supports under Section 504. So you would look at that and say, if it said, for example, there's going to be a group of people, including a building principal, perhaps the Section 504 coordinator, a teacher, etc., who would get together and put together a Section 504 plan to include accommodations. You want to look at what the district's policy is and what their practice is for how they put together 504 plans. Same is true for dispute resolution under Section 504. There are a couple of other things you can do, but each district has to put together a dispute resolution process. So you can request a Section 504 hearing, for example, and instead of going through the IDEA hearing process, you would go through a process that was set up by the school district according to their procedures. There is also the possibility under Section 504 that you can file a federal civil rights complaint with the U.S. Department of Education's Office for Civil Rights. There's pretty specific timelines and requirements on how you do that, but that is a way that anybody can try to resolve a dispute under Section 504.
Okay, great. And also 504 can be used beyond K through 12 education. It can be used in post-secondary education. Can you give an example of a situation where 504 might apply in college, for example?
Sure, yes. 504 it applies whenever you're working with a program that receives federal money, and it doesn't matter what age you are, as long as you have a disability that meets the functional criteria. So, for example, I used to teach a class at Cooley Law School, and I had a student who was hard of hearing and needed an accommodation, what's called a cart machine, along with an operator to help her understand what I was talking about, what I was doing. That's an accommodation that the school had to provide, so she could get access to the programs. There is a limitation. I mean, what they call a reasonable accommodation, and so of course you know that when you see the word reasonable, you know the lawyers were involved in writing it. So the way a reasonable accommodation is identified is you engage in an interactive process where you identify yourself as a person with a disability who is requesting an accommodation to take part in the program, and then you engage in this interactive process with the program to figure out what kind of accommodation is reasonable. And it's a back and forth kind of thing, which depends on the individual circumstance.
Sure. And in a college or university setting, typically those requests are initiated through the Office of Disability Services, or it may be called different things, but that's that type of department at the university?
Yeah, most universities have, although the law doesn't require it. You can ask anyone, but typically college or university will also have a Section 504 coordinator, just like a K-12 school, and there will often be what they call an Office of Student Services or Disability Supports, or some other organization that helps facilitate accommodations. Now, one thing that's, I think, important to understand about accommodations is that they're not the same as modifications to the program itself. So if somebody, say, had a learning disability in math, and they were in college, and they because of their learning disability in math, they couldn't get through math. An example of an accommodation would be if they said, look, I need you to present the material to me in a different way, or I need you to test me in a different way so I can show you what I know about math and meet the requirements of the class. A modification, which is not required, would be, don't make me take math. It may be, I want you to waive the math requirement, and that's a modification to the standards that is within the discretion of the program. So a college can say, no, we want all our graduates to have some background in math, and as long as there's some reasonable relationship between what they're requiring and what the what they're teaching, that's allowed.
Mm-hmm. Okay. All right. So, can you give a brief overview of how a student is deemed eligible for an individualized education program, or IEP, through the Individuals with Disabilities Education Act?
Sure. It starts with a request. The parent makes a request for a special education evaluation. There is a duty called child find, where a school district has the responsibility to identify, locate, and evaluate children who may potentially be eligible for special education. But ultimately, the request for an evaluation comes from a parent. It's a written request, and that triggers a timeline where the school then has 10 school days to respond, either by saying, yes, we're going to go ahead and evaluate you, or no, we don't think there's any information to suggest that you have a disability, and we're going to give you a written notice explaining why we think that. So assuming the school gets back to you and says, yes, we'll go ahead and evaluate, you need to give us consent. And so the parent would then need to consent to an evaluation. And then the school, after that consent is received, that's a written consent, has 30 school days to then complete the evaluation and convene a team to decide whether or not the student is eligible for special education. The evaluation has to meet a number of components. It has to rely on a variety of tests. It can't use a single test score to make a decision. It has to be accommodated for disability, for, say, sensory disability. It has to be valid. It has to be administered by someone who is qualified to administer it. Has to take into account any kind of language issues that a person may have. So those evaluations occur. The team gets together. They decide whether or not the student's eligible. There are two parts to eligibility. One is you have to have a condition that meets one of the 13 categories, and the other is that disability has to adversely impact your education. That's defined very broadly, though, and one of the issues that keeps coming up, in fact, it came up again in our office this week, schools saying, oh, you're doing fine academically, so you can't qualify for special education, and that's incorrect. The school has to look at a whole range of how a student's doing in order to decide whether or not their disability adversely impacts their education. So it's not just about grades. It's not just about academic performance. It's also about how else you're doing in school. You look at that to decide whether the disability is affecting your education. So once kids found eligible, then they convene an IEP team. The two people have to be on the team. There's a teacher and an administrator. The parent has to be invited and brought into the process, but if a parent chooses not to participate, the team can go ahead without them. There is a requirement that a parent consent to the initial provision of special education services. Once that happens, the parent can revoke that consent, but after that, there used to be a requirement that parents sign an IEP, but that's only really true for the first IEP that you have, where you're consenting to the initial provision of services. And then the IEP team convenes to review the IEP at least annually. And at that point, you're supposed to look and see what kind of progress is being made, what changes need to be made, and you review and revise the IEP accordingly.
Okay. Now with epilepsy, in terms of assessment, sometimes with epilepsy, school performance and cognitive function can wax and wane. It can be variable based on how often the child is having seizures. Is there a scenario in which, say, a child is evaluated by the school, they happen to be having a good day, and the school says that the child's not eligible? Is there, but you know, the parent knows that they're on bad days that they're certainly going to struggle with school performance. Is there a scenario in which someone can get an outside evaluation, like a neuropsychological evaluation, and that could be taken as evidence of eligibility?
Well, let me answer the question first. Yes, you can get an outside evaluation, but let me address the issue about the nature of that kind of evaluation. I would suggest that if a school did a one-time snapshot of how a student was doing on a particular day and concluded based on that snapshot that the student didn't have a disability, that's probably not an adequate evaluation. Okay. May not meet the standards for accuracy under the law, and I think could be challenged for that on that basis. But going beyond that, if you don't agree with the school's evaluation, you can ask for an independent evaluation at the school's expense. The school can respond to that in one of two ways. They can either agree to do that and give you some ideas on some people who would be available to do that, and you can choose from that list or choose your own person. Or they get back to you and say, you know what, we think our evaluation is appropriate, and we're going to defend that by requesting a due process hearing. Increasingly, we're seeing schools go to the second route, which is unfortunate. But let me also point out that a parent can bring their own evaluation anytime they want, and that an IEP team has to consider all evidence that is brought before it, including any evaluations that are secured by the parents. So my suggestion on bringing outside evaluations like that is, especially with medical or neuropsychological evaluations, that you make sure that the evaluator is thinking in terms of educational criteria. Very often, what you may find is somebody does an evaluation for a broad purpose, not just for educational purposes, but for lots of other purposes, and they make conclusions that are based on criteria that are not necessarily related to school criteria. So, for example, with a neuropsych, if you're looking at whether or not a child fits the criteria for eligibility under other health impaired, the evaluation has to address those criteria. It may not be the same as simply saying the person has seizures. They're going to have to say, how is this a health condition which affects the student's strength, vitality, or alertness? And I would suggest that you work with the evaluator to make sure that they answer those questions that would be posed by the educational standards as well as the other standards. Okay. But let me say one more thing about that too. That is that you present the evaluation to the IEP team. The team has to consider it, but they do not have to agree with it. Okay. And that's something that gets people kind of bent out of shape a little bit now and then. They say, well, I brought my neuropsychologist in and they gave them this information. Isn't that enough? The school has to consider the information but does not have to agree with it. They have to explain, when they make a decision, what information they considered and why they didn't agree with it. So there is a requirement that they provide notice that explains the basis for their decision, but they don't have to agree with the outside evaluation. Okay. All right. So can you give a few examples of the wide range of services and supports that can be included in an IEP? Sure. The most common one people think of is specialized instruction, and that can occur in a variety of settings. From a teacher has certification in some special education area. It does not have to be a particular area that matches up with your area of eligibility, but it can be anybody with any kind of specialized certificate in, say, teaching people with learning disabilities or teaching people with cognitive disabilities, emotional impairments, etc. Sometimes those services are provided in general education settings. Sometimes they're provided in separate settings in special education classrooms. There are lots of other related services, though, such as occupational and physical therapy, speech therapy, assistive technology, school social work services. There's a very long list. I'll take this opportunity to plug our Special Education Advocates Manual, which is available on our website for free. And if you look at Chapter 2 in that manual that talks about special education and related services, you'll see a reference to a federal regulation called 34 CFR 300.34, which gives a very long and non-exhaustive list of various related services that can be provided for someone who is in special education.
Okay. So in my experience, many parents are not aware that a transition plan is a required component of an IEP. Often we'll mention that, and transition plan, I didn't know that was a thing. So what are some of the key elements of a good transition plan, and do you have any idea why parents aren't being informed of this in many cases? I have some
theories to answer your second question. Let me first of all frame this a little bit. When we're talking about transition, we're talking about transition from school to whatever you're going to do after school, and that may be employment, it may be post-secondary education, it may be career technical education, it may be some other kind of independent living, it may be some other situation. Just like anybody else, and my theory about why people don't think about transition plans is that for a long time, I think that we've been combating a cultural assumption that students with disabilities are not able to work or live in the community to the extent that everyone else does, and this is actually part of what IDEA is designed to combat. Is this whole notion that it presents the notion that students with disabilities are students first, and that they should be treated just like any other student and have the same rights and access to programs and supports that anyone else has. So when you think about transition, the first thing I try to think about is what does a school do to support a student who doesn't have a disability, and do students with disabilities have access to those things? So one thing that comes to mind is that in high school, starting in 9th grade, schools are required under state law to do what's called an educational development plan, which is kind of a career transition plan for students. And students with disabilities should have access to those kinds of supports, that kind of planning, as well as anybody else. So that's something that starts earlier. Some school districts start those kinds of supports even earlier than 9th grade. So students with disabilities should be part of that. Now, when you think about transition under IDEA, this is a specific service that starts at age 16. It can start earlier, and many of us wish that it still started earlier, but there were changes in the law some years ago that pushed it up to 16. It is part of the IEP, and it is designed to support the needs of students as they're going to make the transition into adult life. It's based on a student's strengths, interests, and preferences. And so that old notion about you can have any kind of work support you like as long as it's related to custodial work, landscaping, or house cleaning, is not it doesn't follow the law. The law says that you tailor a person's interests to meet tailor a person's transition supports to meet their strengths, interests, and preferences. And so that in turn is based on a good assessment that is going to take into account what a student is interested in, what their strengths are, and what they want to try to pursue. It should look at a wide range of domains. It's not just about we're getting you ready to put you into a transition program. It should look at a wide range of options such as post-secondary education, integrated or supported employment, some other kind of continuing education, and also independent living and community participation, because those are also important parts of what happens to a person when they're an adult, and those are skills that should be supported in transition as well. So the assumption is it really is bearing out the promise of IDEA that that students with disabilities are students first, and they're going to be ready to take their place in the community just like everybody else. And the transition supports are designed to do that. The last thing I say about transition is that this is the time, more so than any other time, when you really start to involve other community agencies in addition to schools. So in the transition planning process, you should be inviting, if you're receiving services from a Center for Independent Living, from Community Mental Health, from Michigan Rehabilitation Services, those agencies should now begin to be brought into a student's life if they are eligible and then they choose to use those services. And the student should be there. The student should be part of the IEP process in any situation, but for the most part, the student should definitely be part of the transition planning process, because because part of that process is helping the student become an effective self-advocate and learning how they're going to negotiate life as an adult.
Great, right. So we'll move on to employment shortly. I have just one more question about IEPs, though. What were some of the most common pitfalls when it comes to IEPs, and then what are some of the primary mechanisms for either preventing or resolving disputes under IDEA?
I think that one of the primary pitfalls, and I'll channel my friend Sandy Koski, who trains for the Michigan Alliance for Families, that you don't start at the beginning, which is how is the student doing? There's a part of the IEP called a present level of academic achievement and functional performance that a lot of people overlook. It talks not just about a student's problems and failings, but also their strengths and ways they learn well. Most of the goals that a student is going to have in an IEP are going to be based on that present level of performance, and most of the services and supports that you receive in special education are going to be based on the goals that are identified as part of that. So I think that one of the common pitfalls is glossing over the preliminary, what many people think of as the preliminary parts, the present levels of performance, and making sure that everyone understands those and that those are accurate and up to date. I think the other thing that happens is that people tend to adopt goals that are not measurable, and so you don't really know when you're succeeding and you don't know when you're not. So it's really important to think about, when you're talking about goals and how you're going to measure progress, finding some objective way that a person who is not familiar at all with your student could step in and actually identify whether a student was making progress or not. If you leave it up to, say, self-observation, self-reporting, teacher observation, those kinds of things, those are really easily become subjective measures that are really hard to prove or disprove. So I think that measurement's an important thing. As far as dispute resolution goes, there are a variety of ways to resolve disputes. There's free mediation available through the state. There's what's also called IEP facilitation. If you have a situation where the problem is there's just a problem of communication between the parent and school, which often happens, you can bring in a third. The parties can agree to bring in a third person to facilitate the IEP. There is a complaint process where you can write a letter to the state if you think the school is not following the law, and that includes not providing a free appropriate public education, which is the standard. And there is a hearing process, which is which is a litigious process. You're almost always going to have a trained and experienced school district lawyer on the other side if you file a request for a hearing. The thing you need to know about complaints and hearings: complaints have to be filed within a year after the thing that happens that you're complaining about. Due process hearing requests have to be filed within 2 years after the thing that you're not happy about. Due process hearing requests are the only way that you can invoke what's called stay put, which means that if the school wants to make a change that you don't like and you want to slow it down, the only way you can really stop that from happening is by requesting a due process hearing. As I say, due process hearings they're basically trials. if you win, you can bring an attorney. If you win, the school district pays the attorney's fees for your attorney. That sounds great, except that it doesn't sound great to schools, but it sounds great for parents, except that what often happens if you win and make a claim for attorney's fees is that the school district will likely appeal to federal court. So you're gonna wind up litigating the case in federal court, and that's often more than people bargain for.
Okay, so trying to avoid that if possible.
I wish I had better news. Better news about dispute resolution, but it's kind of a mess.
Right. Okay, well, let's move on to employment. One of the primary laws that protects the employment rights of people with disabilities is the Americans with Disabilities Act, or ADA, specifically Title I. Can you give an overview of how the ADA provides access to employment opportunities for people with disabilities?
Sure. It's an anti-discrimination law. Title I is an anti-discrimination law. It is modeled after Section 504, which in turn is modeled after the Civil Rights Act of 1964, prohibiting discrimination based on race. And it basically says that an employer can't discriminate based on disability and has to provide reasonable accommodations for employees who request them. The reasonable accommodation process is very similar to what we talked about under Section 504 in education. The employee or the applicant says, I'm a person with a disability. I needed a reasonable accommodation in order to do this job. And then the employer enters into an interactive process with the employee to try to figure out a way to provide the accommodation in a way that the employee can do the job. And those accommodations can take a whole wide variety of forms.
Okay. Now, as with most laws, there are some loopholes that can be used to get around the ADA's requirements. Can you discuss some of the gray areas in the language of the law and how people with disabilities can prevent this ambiguity from being exploited by employers? Okay.
So, first of all, remember there's a ban on discrimination based on disability. And so if a person asks you about it, just says, do you have a disability, that's illegal. Mm-hmm. All right. So because it's not related at all to what an employer needs. What an employer can ask is they can ask, can you do the job either with or without accommodations? And the answer to that question is yes or no. You don't have to reveal at that point whether you need accommodations. So one of the loopholes, I guess you call it a loophole, is that the employer gets to define what the essential functions of the job are going to be. And sometimes the employer goes a little far in saying, here's what we need the person to be able to do, and those are not actually things that a person does in the job. For example, if an employer says, in order for us to hire you, you have to have a driver's license. You think, okay, well, that's not a big deal, except it may be for a person, who has trouble, because of epilepsy, may have trouble getting a driver's license. The question you would ask then is driving part of the job? Or do you need, is it enough you're asking for a driver's license just because you're used to it, or worse, because they're trying to screen out people who can't get driver's licenses for some disability-related reason. And so when you're defining the essential function of the job, the essential function actually has to be related to what the job actually does. If there's no driving involved, there would be no reason to have a driver's license. Another defense that an employer often uses is what they call undue hardship, where they say we can't afford to provide the accommodations. And in that circumstance, that's where the interactive process is particularly helpful, because the literature shows that most accommodations are cheap. They may cost less than like $50 to $100, and that's really not much of a hardship for any employer. When you look at whether or not an employer may jump to a conclusion, for example, if someone has a mobility disability, saying, well, I have to put in an elevator, or I have to put in electric doors, or I have to do something that's really, really expensive, when in fact the interactive process would probably reveal that there are other accommodations that would do the same thing without without costing a whole bunch of money. There is what's called the direct threat defense, where an employer says, well, this is too dangerous. I can't have you around heavy stuff because it may fall on you or something. And the thing to remember about the direct threat defense is that it really has to be specific and not based on some stereotype or label of a disability. It really has to be based on the person's specific situation and the specific situation that they're found in. So those are probably the three that I think of, along with this whole idea about asking about disability on an application. Really, an employer is pretty limited in how they can ask about those things until a person has a job offer in hand. And then once there's a job offer in hand, then an employer can require that you have a medical exam or those kinds of things. But it has to be a requirement that applies to everyone, not just a person with a disability.
Right.
So if they're going to require that person take like a drug test or something like that, then that has to apply to everyone. And and that there has to be some relationship to the needs of the business. So they can't just, arbitrarily say we're going to make you, lift some weight or something like that, or we're going to make you stand for a particular amount of time, if the job doesn't actually require any of those things, and if they apply to everyone.
Right. So you'd mentioned the asking about disability or health status on an application or during an interview. I have heard from multiple people that they've received applications that have a question saying, do you have a disability or health condition that might interfere with your ability to do the job? And it's often listed. Maybe the question might be listed as optional, or it will have a yes, no, or refuse to answer, or something like that. It seems like a very difficult situation for people to be put in, because if you say that yes, then that's a red flag that you may have a disability. If you say or refuse to answer or leave it blank, then that's can also be a red flag. So how should people respond in situations like that? And is that something that should be reported to the EEOC if someone if an employer does have an application that asks that question?
I was just reading, to answer your second question first, I was just looking, you probably know that Walmart has been under fire recently because they changed the job descriptions for their greeters. And so I was looking to see, whether or not there were any kinds of EEOC claims against Walmart, and there was, in fact, a consent decree that they entered into. That's a court-supervised agreement that they entered into, that the U.S. Equal Employment Opportunity Commission entered into with Walmart in the early 2000s over questions on applications. And so what that meant was that the EEOC sued Walmart, and they entered into a settlement where Walmart agreed to follow the law. So I think the EEOC definitely looks at that issue. Their guidance says it's illegal for people to ask those kinds of "do you have a disability" questions, and I think that it's worth a complaint. I guess I agree with you. It's a really difficult situation that a person is put in. You want the job, you leave it blank. You run the risk of drawing attention to yourself. If you answer it yes, then you run the risk, and you've disclosed you have a disability. When you don't have to. The allowable question is, can you do the job with or without accommodations? Here's a copy of the job description. Here's what you have to do. Can you do it with or without accommodations? It should not be asking about whether you have a disability. One thing I would say don't do is lie, because what then happens is you're going to be accused of falsifying your application. So don't answer it. If you have a disability and say, do you have a disability? You say no. That could create problems for you. But beyond that, I'm not sure I have really good advice on whether to leave it blank or answer it. I think it's an illegal question, and of course, whether saying something's illegal is one thing, and going to the lengths to complain about it is something else entirely. I'm not sure I really get advice on that, other than don't make something up.
Sure.
You know, I would probably, if it was me, I'd probably leave it blank.
Yeah, and there may, I've heard of situations where it says, like, do you have a disability that would interfere with your ability to do the job? And in that case, I think it would be reasonable, even if you do have a disability, to answer no, because you're saying by answering no that your disability would not interfere with your ability to do the job. So that might be one option.
You could, that's true.
Depending
you
on
then have to argue
the
about
question
that with the employer.
Right.
Right.
All right. Can you just briefly review the process of filing an EEOC charge and what the possible responses people might get from the EEOC after filing a charge?
Sure. You file. There's a complaint form you fill out. The EEOC makes that available. You can go to their website. You can call them. We have copies. You can call our office. We can send you the forms. You can call in a complaint. But one thing you need to know is that you have to file it within 180 days of when the incident occurs.
And is that
300?
Is it 300 in Michigan because of the?
It's 300. It's 300. You're right. It's 300 days. I'm sorry. Yeah, it's 300 days, and you can file it either with the EEOC or with the State Department of Civil Rights, and they cross refer to each other.
Oh, okay.
I'm not sure I would trust that, given the nature of state bureaucracies
right.
and federal bureaucracies. I think I would probably file it both places myself, but I'm a belt and suspenders kind of guy. 300 days. The EEOC gets your complaint. They are going to take a look at it. They may offer you what's called early resolution. It's like mediation, where they may try to get resolution through mediation. That's voluntary. You don't have to accept it. They'll come back with one of three responses. Either they'll come back with, yes, we think there was a violation, and so we're willing to take this up for you. What the EEOC does is they essentially they stand in your shoes as the aggrieved party if an employer does something that violates the law, and they move forward basically on your behalf. There's good and bad to that. One is that the good thing is you've got somebody doing this for you. You don't have to hire a lawyer on your own. The downside is that you are limited in the kinds of remedies that you're going to get in terms of damages. If you feel like you've been harmed significantly by what the employer did, what you're going to get from the EEOC, if they resolve it, is some kind of back pay, maybe reinstatement, those kinds of things. But you may be limited in what kind of damages you can claim. The second possible response is they say, we don't think there was a violation, and you're free then to do whatever you want on your own, but we're not going to help you, and we don't think this was a violation. The third response, which is probably the most common one, is we don't know because we don't have enough people to investigate this in a reasonable amount of time. We're going to give you the right to go ahead on your own. We call it our right to sue letter. And then that sets a timeline in motion where you've got, I think, 90 days to then move forward on your own. That's a tricky business because it doesn't give you a lot of time. Especially if you decide you want to file a suit on your own. But what it does is essentially gives you the green light to go forward on your own. The thing about the EEOC is before you file a suit under Title I of the ADA, you have to file an EEOC complaint. You can't go around it. You have to go through them first. But often what they will do is they'll give you a license to go ahead without making a finding on your complaint.
Okay. All right, so let's shift now to the Family and Medical Leave Act, or FMLA, and that allows people to take unpaid time off from work to attend to their own health needs or the needs of an immediate family member. Can you give some examples of the benefits and shortcomings of this law, particularly as it applies to people with unpredictable and episodic conditions like epilepsy?
Sure. So the biggest benefit is that you get to keep your job even if you have to miss time. So your job is protected, and you don't get paid, which is one of the downsides. But they can't fire you because of a health condition, what's called a serious health condition, or your time to either care for yourself or for somebody else. For a person with epilepsy, it's one of the benefits is that you actually can claim it as an intermittent benefit. I mean, there is a time limit of 12 weeks, but you don't have to take all those 12 weeks all at the same time. So you can take, if the nature of your health condition is such that you can't be at work for a couple of days, but you can then for a couple of days after that, you can take it intermittently. So that is something that's helpful. Probably the downside, besides the fact that it's unpaid leave, the employer has discretion to decide when your time period starts. And so when you they give you notice that if you're out, you're not there doing the job, they say your FMLA leave or FMLA leave has started. The other kind of downsides about FMLA is that there is a minimum employer size that it applies to. I think it's 50 employers or more, 50 employees or more, and so it doesn't apply to small businesses necessarily. Now, having said that, many times a small business may adopt an employment policy that follows FMLA, and so it's worth checking to see what your employer's policy is on that before you assume that you're not going to have any protections under the law. They may have agreed to that. For example, when we were our agency, we were under 50 employees. Our employment policy said to employees when they came on that we were going to give them basically FMLA-like rights. So that's something the employer might choose to do in its agreement with employees. The other problem with FMLA is that you have to work a minimum number of hours before you qualify. So I think it's like 1,200 hours or something that you have to put in as an employee before you can qualify for protection. So you couldn't start like in a job, work there for a month, and then claim FMLA. Nor can you continue to. Once you get to your 12 weeks, you have to work a certain number of hours before you would build up to where you can claim that again. So it's not an unlimited benefit. It is subject to some trickiness in how you claim it and how your employer reacts to it. Your employer it's not on top of sick leave. So if your employer provides sick leave, they can make you use your sick leave and your FMLA leave concurrently. So it's a tricky law. I mean, it's a good benefit, but there are some tricks to it.
Yeah, certainly. I wasn't aware of the having to work a certain number of hours before qualifying. That seems like particularly with someone with epilepsy, maybe who's been on Social Security disability benefits for a while and is trying to get back to work. Maybe their condition has improved, but maybe they're not completely seizure free. It seems like that could be a challenge getting started in a new job if you have to reach that threshold before you can qualify.
Right.
Yeah. So you mentioned the 50 employees or more. I'd forgotten to ask about that with the ADA. Does that apply? Is there a limit of employees? I seem to remember it being 15.
I don't want to. I think it's 15. 15. Okay. Yeah, I think it's actually under state law. I think it's 15 under the Persons with Disabilities Civil Rights Act. Okay. So you're talking about, it's a smaller number, but there is a minimum number under Title I as well.
Okay. So those in smaller organizations really have no recourse if there's employment discrimination, or could they try under sorry.
They could try under the State Civil Rights Act, the Persons with Disabilities Civil Rights Act, or they could, again, check to see if their employer gets any federal money. They might be subject to Section 504.
Okay, that's a good point. All right, so the Fair Housing Act protects people from housing discrimination. So how does this law promote housing accessibility, and what are some of the common examples of housing discrimination against people with disabilities that this law protects against?
Sure. So the Fair Housing Act, I mean, it's similar to the Civil Rights Act and the Americans with Disabilities Act. It comes from that common root, the Civil Rights Act, as it applies to housing. So it applies to certainly sale or rental of housing. I'd say probably the three areas where you see the most activity in the Fair Housing Act would be whether it would be evictions. Certainly, we see whether if you're doing something that a landlord doesn't like, or that neighbors complain about, or that something's related to disability, and the landlord says, well, I'm going to evict you for that reason. If you say you use a wheelchair and you bang into the doors, or you have an attendant over, if you have a tenant care, you have family members there to provide support for you or care for you, or if an ambulance shows up now and then. Those would be examples of disability-related issues. If a landlord were to say, then, oh well, you have people over at your place all the time. That's a violation of the rules. We're going to evict you. The Fair Housing Act might protect you in those kind of circumstances. Secondly, would be if there's an accessibility issue within a place, and this is usually related to apartments, but also can be related to condominiums. We see it a lot coming up in condominiums. We see it sometimes coming up with mobile homes, where you want to make a modification to your place so you can make it accessible, and the landlord or the condo association or the park or somebody says, no, you can't do that because it's a violation of our rules. You can't have a ramp outside because it changes the way the condo looks, or you can't you can't put in a different toilet, or you can't put in any other kinds of accommodations either inside or outside your place. And the Fair Housing Act would give you some protection to at least be able to do that. It doesn't necessarily require the landlord pay for it, unless the modification or the accommodations in a common area. And then the third thing that often happens, and this is a little bit different than some of the other disability rights laws, is that the Fair Housing Act protects access to emotional support animals. And that's not something that's protected by the Americans with Disabilities Act. They allow access to service animals. Those are animals that perform some task, as opposed to an emotional support animal. Fair Housing Act does make provision for people to have emotional support animals. Those provisions are often under threat because landlords perceive them as being misused, and so there's constant danger. There was a bill in the last legislative session that would have basically criminalized making a false claim of an emotional support animal, and would have given broad access to landlords to health records for renters, which ultimately did not pass. It was opposed by a number of people and didn't pass. But so those are some differences between the Fair Housing Act and some of the other anti-discrimination laws.
Okay, great. So I'm actually, in the interest of time, I'm going to skip over the question about sections 2 and 3 of the ADA, but if people do have questions about that during the Q&A portion, feel free to ask. But the Elliot Larson Civil Rights Act, which I think we've referenced, is a broad civil rights law in Michigan that has some overlap with some of the other laws that we've discussed, and we've kind of referenced some of those. Are there? Can you talk about a few other situations in which this law may come into play for people with disabilities?
Sure. So this is Michigan's version of the Civil Rights Act, and so it applies to race, gender, but also protects against discrimination based on height, weight, familial status, or pregnancy or related medical conditions. So there may be some circumstances, where somebody might be subject to discrimination based on some of these situations. Probably the most common one I can think of is that if you have live-in caregivers and you're subject to discrimination, based on the fact that you have additional people with you because of your disability. So there may be some other characteristics, and the enforcement strategies and sort of the theories about how people violate these laws are, there are some common threads between these kinds of civil rights laws and disability-related civil rights laws.
Okay. People with epilepsy are at risk for two recurring problems with the criminal justice system. One is when people with epilepsy are denied access to their medications while in jail or prison. We've had multiple situations where that's happened. The other is when people are subjected to excessive force, arrested, or inappropriately detained or prosecuted due to behaviors that occurred during the seizure or as a result of post-seizure confusion, like maybe failing to respond to commands because they're in that post-ictal phase or they're actually in the midst of a seizure. And this can happen with people with disabilities that affect communication or comprehension as well. So is there a particular law or set of laws that people can turn to if they find themselves in one of these situations?
I would preface this by saying that the best way to deal with these is prevention and training police officers to recognize situations where this might happen,
right.
Or if they are in a small police force and happen to know you, say, look, this could happen now and then, so we want to make sure that you understand that if they don't respond to a command, it's not because they're ignoring you or because they're threatening, it's because they're having a seizure. That being said, if that's not true, that's not possible in all areas. The ADA and Section 504 apply to law enforcement. They apply to jails and prisons. They apply to the criminal justice system. And so you can assert your right to reasonable accommodations, especially in the arrest process, certainly in the charging process, in the process of going through the criminal justice, the trial system, and while you're in jail or while you're in prison. In addition to that, there are constitutional protections that are invoked against states through the U.S. Constitution and applied to the states through the 14th Amendment. Probably the most relevant ones are the right to be free from cruel and unusual punishment. So if you're in a jail or prison being denied access to your medications, you're being restrained, improperly, if you're locked in solitary confinement without any kind of treatment, there may be some violations of Eighth Amendment rights. There may also be violations of rights on arrest and search and seizure. If a person is not, familiar with Miranda warnings, you have the right to remain silent, etc. If a person doesn't understand those, they're not in a position where they're being communicated properly, that can be both a constitutional violation and an ADA or Section 504 violation. As far as issues about health care and access to medications and such those are hard to address, but they're probably the closest kind of thing you're going to get probably is some kind of Eighth Amendment or some kind of what's called a substantive due process, kind of arbitrary and capricious kind of behavior that's essentially going to be a civil rights or constitutional theory as to how you're going to get access to that. I found that practically speaking, the best way, probably the best sources, one source of support for somebody who's in jail, for example, and doesn't have access to their meds is the chaplain. Often they have probably as good access, other than the person's lawyer, who may or may not be involved with the person at that point in the case. Often a jail chaplain has access to the people that people might not otherwise have, and it's a way to get information to the people in the jail that the person needs medications, and communicate that way. And then most community mental health programs have some kind of jail support services. They vary in effectiveness and how much they are able to actually do, but that's always another consideration to try to bring in. A lot of jails, their issue is that they don't allow outside medications in because they see everybody is trying to smuggle drugs into jail, and that's probably overbroad, especially for someone who needs anti-seizure medication. They don't, most jails don't, or sheriffs don't want, they don't want somebody dying. They don't want somebody getting really, really sick on their watch, and so, they at the same time realize that they struggle a lot with providing what they consider to be a primary role in providing medical care and mental health treatment to people when people are not otherwise getting those services elsewhere.
Right. So while there are ways to file a complaint or discrimination charge related to all of these laws we've discussed, there may be circumstances, as we've alluded to, in which legal advice or representation is needed. What are some available resources that offer free or low-cost legal assistance or provide specific guidance with disability laws?
Well, I wish I could tell you that there are lots of low-cost lawyers out there ready to take these cases, but I can't.
Right.
We have our agency has an information and referral service that gives advice on issues. It's free and confidential, and you can access that either through our toll-free 800 number or through our website, mpas.org. It's a confidential portal that you can put in a question and we can respond to it. If you qualify for legal services, many legal services agencies take some of these kinds of cases or will provide you advice. With regard to special education in particular, there's actually not just that, but with a number of other issues that relate to people, low-income people. There's a great website called MichiganLegalHelp.org, and that's run by the Michigan State Bar Foundation, and run by a group called the Michigan Poverty Law Program. And some of our special education materials are on that website, and it also has a great interactive process you can go through to write letters about issues like public benefits, landlord-tenant issues, family law matters, and some education matters as well. There are some situations where you get appointed counsel, mostly in the criminal justice setting, but also if there's any kind of request for guardianship or if there's a juvenile matter, you'll get appointed counsel. And in some cases, there are private lawyers who will take on cases because there is the possibility of contingency fees. Probably the two areas in disability rights that are most common for that would be employment discrimination, because there is the possibility of getting an award based on a person's back pay, and Social Security eligibility, because of if you prevail on that, then there's a back award, and the attorney or the advocate is entitled to a statutory share of that. That's usually like 10 or 11% of the back award. Right. So there are private lawyers who take those cases on. There are lawyers who do estate planning, guardianship, those kinds of things. They all charge. And I'd say other than that, like I said, Legal Services has what they call the call center, which serves a lot of the counties in Michigan. And most legal services have a information and referral line. There's often a hold time on those, and if you are not low income, you're not going to be eligible for that. So I wish I had better news about the availability of representation, but it's just not there. Right. Not even true for poor people. I mean, there isn't enough legal services to serve even the low income people.
Right. All right. So I think we'll go ahead and open it up for questions. Before we do so, though, do you have any closing thoughts to wrap up what we've discussed?
Yeah. I mean, there are lots of other service systems and laws to be aware of, and I guess that the two that I would talk about I would suggest the most would be Medicaid and guardianship laws. And so those are both areas that affect people with disabilities, people with epilepsy. Medicare is also an important one. Those are the Medicaid, and in particular, is the source for a lot of support services that help people live in the community. And so that's a service system that that even if you're not on supplemental security income, there are certain waiver services that you might be eligible for. And so it's important to just know that those services exist.
Right. And is there a particular complaint process, or if you're not getting access to services that you're eligible for through Medicaid, is there do you just go to the Department of Health and Human Services? How do you I guess where do you go to get resolution?
Yeah, maybe I shouldn't have brought it up. It's a complicated question to answer. But I mean, it depends on who you're getting what kind of services they are and who you're getting them from. Basically speaking, there is usually a local resolution process that you have to go through first, and that's usually a product of some kind of Medicaid managed care program. So if you're getting Medicaid services through a health insurance company, for example, you have a dispute, they will have a local resolution thing that you have to do first within limits. I mean, they can't make you go through it for years and years, but you have to try that first, and then if that doesn't work, you can request Medicaid hearing. That's sort of the basic general way you challenge Medicaid decisions.
Okay, great. All right, so we'll go ahead and open it up for questions. Okay, who would like to get us started with a question?
Yeah, this is Cindy. I've got three comments. Hi. You were talking about criteria for an IEP. Is there anywhere that is, Social Security has the Blue Book for adult listings. Is there any written criteria, objective criteria, written anywhere for IEP eligibility?
Yes, and it's not necessarily related to the Blue Book, but
no, it's not. But I wanted in that type of format.
They're not. Right. Because, and not only that, the definitions for eligibility under IDEA are educational and not medical. They're often not related at all to any kind of medical condition. Probably the best place I can suggest you look is you start with the state regulations defining each disability.
Okay.
All right, and those are in the if you look at our manual, if you look in, I think it's chapter 3.
Yeah.
It's on our website.
Okay.
And look at the state definitions of each of the categories. That'll give you some guidance. They're not totally specific, but they give you some guidance, especially if you're learning disabilities. Then the other place to look is in your county. I don't know what county you live in, but
Wayne.
Look at your intermediate school district policies to see if they have any additional definitions, because some intermediate school districts, like Wayne Risa, for example, has a fairly detailed description on what their definitions of different categories are, and we would argue some of those categories are not necessarily right, but they do try to make them specific. So those are the two places that I would start.
Okay, another one now. Russ mentioned about employment questionnaires. I see continuously voluntary health questionnaires. Do you have this health condition, this health condition, this health condition? And it's all voluntary. And I want to know if the EEOC is looking into that and starting any type of movement to prevent that. Because it's not saying, do you have this disability, but do you have this health condition?
So let me ask
you,
are those questionnaires for existing employees or people who are being considered for
It's for people. Actually, this was from a hospital, believe it or not, for someone who was applying for a job.
Yeah, it's interesting. All I know is what I read with the EEOC and what they find. I know that they have in the past they have brought suit against companies that ask these pre-employment questionnaires.
Yes.
They shouldn't be asking those questions to people.
No.
They shouldn't be asking those questions to people before they hire them. Now, what they can do, there may be a health-related reason why if you had something that was a communicable disease, I suppose, and you went to work in a hospital, that might be an issue. But
sure, but they're going to do a pre-employment physical.
That should be a post-employment. Right, that should be a post-hire kind of question.
Right, post-hire issue, exactly.
Right.
Okay.
Last one I have is my big complaint about the driver's license. Are we ever going to see that as being banned as a form of ID? Because that opens people up to letting people know a possible disability. Are we ever going to start a movement on that?
So I don't know. I mean, I know I've heard people talking about, that whether or not that's whether that's a bona fide essential, qualification for a job. I think that, honestly, what's going to make that change faster than anything else is the advent of autonomous vehicles. Yes. Because that's going to directly raise the question then, if you're going to ride around in a driverless car, why do you need a driver's license?
Exactly.
And we're certainly raising that. And, there is a governor's council on future mobility that is looking at some of the policy issues around what's going to happen with driverless cars. And, I mean, those are coming. And that will change everything we do as far as driver's licenses and IDs. One thing that I think is hopeful, though, and maybe this is an avenue, is, I just heard the Secretary of State speak this morning about different reforms that she's trying out at the Secretary of State's office, and I wonder if it might not be worth, raising this issue with the new Secretary of State.
Oh, I'd love it, because it just, why don't you drive? In Michigan, it's taken for granted.
She says all you have to do is just email her. So you can email her after.
Great.
Give me the email. Get in contact with Russ and give me the email, and I'd love to.
Secretary at sos.michigan.gov.
Okay. So, Mark, we're close to being out of time, and I know there's probably some more people who have some questions. Do you have a possibility of staying on for an extra 5 minutes or so?
Sure.
Okay.
Yeah, and
great.
Let me also, I can, and let me also say that if you have any disability-related questions or issues, we do have our information and referral service that's free and confidential. So you can contact us through our 800 number or through the website, and we'll have a live person actually talk to you.
Okay, great. Thank you so much. So I just want to make sure, do other people have questions? We'll have about...
I have a question related to the applying for jobs.
Okay.
I've been applying for a lot of jobs, but what I've also found out on filling out an application is they will list job duties, and under that, it's optional. They will ask if they need to accommodate any medical conditions that you may have to be able to perform those duties.
I think that's an illegal question. I mean, the proper question is, can you do the duties of the job either with or without accommodations? And the answer is either yes or no.
Okay.
Yes. That's my opinion. I mean, I think that's complainable.
Yeah, This is coming up frequently enough that I think people need to start letting the EEOC know about this, because it's clearly a lot of employers seem to be doing it. So, another person had a question that started to talk.
Yes, my name is Eva.
Sorry.
Hello?
Go ahead.
Yes. Okay. Can we have the 800 number to call? Mine is a more complex case, and I don't want to take up everybody's time. So
sure, 800. Yeah, 800 288 288 5923.
And the website that you said to go to?
MPAS.org.
MPA, S as in Sam?
Yep.
S as in Sam. Yep.
Okay.
Thank you.
All right, because my son is 40 years old, and he's been employed at the same place for 18 years, has epilepsy, they know about it, and he had a car accident, and they took him off of his job and have now moved him all the way down to janitor. And it's
yeah, that's
just
a complicated question, all right. Yeah, give us a call.
Yeah, I will do that. Thank you.
Great, great.
Okay.
another person?
I would,
Great.
can I just suggest one more thing? If you call the INR number, you might want to have if your son is willing to call with you, that would make it even faster.
Okay. I will have him with me. He's at work right now. So.
Right. Okay.
Great.
Thank you.
Great. Someone else had started asking a question?
Oh, that was me.
Yes.
I was just gonna ask the 1-800 number.
Oh, okay.
I already wrote it down.
Got it. And someone else just started talking as well?
Russ, this is Dave. Very quickly. I'm in a situation where I had a skilled trade for 25 years, and then I acquired epilepsy, and then I had the surgery, and I'm on the medication, and I was deemed totally and permanently disabled, which is pretty much the fact that you're unable to perform the duties you did in the skilled trade you are. So what happens now? I mean, I would love to work and meet some sort of criteria to meet those standards again, but I'm not sure that I can, and maybe that's too complicated for the time we have.
Well, I don't think that's even a thing. Yeah, I don't think that's you can't be declared totally. Mark, do you want to talk about that?
Sure. Who told you that? Was it your employer? Was it a disability?
My neurologist wrote that for Social Security, that I'm totally and permanently disabled, and that meant, in their perspective, that I cannot do the skilled trade job that I did in the past because of a disability that I've had. So that's fundamentally it.
Okay, so it's,
and it sounds scary.
Are you getting any disability benefits as a result? Then, or are you getting either long-term disability or SSDI?
Social Security disability.
Yeah. Are you getting Social Security disability?
Yes, sir.
Okay, so Social Security disability has a number of work incentive programs.
Yes.
And so I suggest you call us and we can get you some information about those. And because they want you to be able to work. The last thing Social Security wants is they want people on disability forever. They want people to be able to work, and there are fairly complicated rules about how much you can work and how much you can earn before, there's a trial work period. There's all kinds of work incentives. So I'd say start with calling us, and we can get you some basic information about what those are. There's a thing called somebody mentioned the Blue Book. There's actually there's a work incentive book in Social Security called the Red Book, which talks about Social Security work incentives. So yeah, there's a lot you can look at.
I know there's a ticket to work, but go ahead.
Right. That's one of them.
Right, and I think another important point is that even if you might not be able to work in the field that you did work in, you very, very well may be able to use some of those skills in another field that may be not as demanding, but that you still can be productive in. So I would love to. I'm surprised that a neurologist would ever kind of use that terminology in saying that you're permanently and completely disabled, like indefinitely forever. It just kind of seems overly restrictive. So I think there's
scary.
I think there's definitely a
way. They're trying to get They're probably trying to get you onto Social Security.
Yeah, exactly. So, okay, well, we are out of time, so I do want to thank everyone for joining us today. And as Mark suggested, if you do have further questions, you have the number and website for Michigan Protection and Advocacy Service. And Mark, thank you so much for covering such a huge and complicated topic and doing it so well. So thanks again, everyone.
My pleasure.
And our next call is going to be on April 3rd from noon to 1:30 on epilepsy in infants and toddlers with Renee Schellhaus. Dr. Renee Schellhaus is a pediatric epileptologist. And if anyone has any further questions, please visit our website at epilepsymichigan.org or call our 1-800 number at 800-377-6226. Thanks, everyone.
All right. Bye-bye.
Thank you.
Thank you.